Okay, so this is where we left off from the last video, and we're looking in secondary authority. This is NIMR on copyright. We're looking for case law, so we're in the fourth step of the research process. And specifically, we're looking for any rules that come out of case law that will interpret our statute, interpret our four factors, help us, resolve our issues. So that's kind of where we're at. Now, this section really appealed to me because it's kind of along the lines of our topic, where our artist, our client, is kind of doing a satire on, law school and whatnot. But in the back of my mind, there's this new case, right, that I keep wondering about, this Oracle case. So I want to go and see what they did or what happened in that case. And so they added this section at the end. So I'm going to read in here, and then I'll come back. So basically, this Oracle case is a situation where Google used some of Oracle's code, and Oracle said that was a copyright infringement. But note here that it said that 4 cases have looked at the fair use question, which is our question. So I'm going to hit on 902 here. It looks like we could go read about those, but I'm not ready to jump yet. And it looks like the court opened with the second fair use factor, which normally they go in order of 1, 2, 3, 4. So this quote here, where they're talking about the nature should be looked at first, is interesting. So I'm actually going to go into the actual opinion now and read. So again, footnotes are the way you go from secondary authority into primary authority here. So let's read here. So we're actually looking at the Oracle case now. So as I'm scrolling to non-point section, I just want to remind you that as we're reading a case, we're always looking for black letter rules and the story to analogize to. And just from reading the facts here, I can tell you that this story is quite a bit different than ours. It's about computer programming. There are specific rules baked into the Copyright Act that pertain to computers. So there's not a lot here factually that applies to our case. So I don't think we're going to use this case as an analogy factually, but it might have some good black letter rules that we'll want to use. So I'm paying particular attention to this section here where it's laying out our statute. That signals to me that, okay, now they're going to be saying some things that could be relevant, and I just highlighted this one here. We have understood the provision to set forth general principles, the application of which requires judicial balancing. So this is one of those ancillary kind of secondary rules, but it just goes to the nature of how you're supposed to balance these factors. So I'm going to grab this actually and use this in our case. So hold on one second. So I will put this in my plan. So here we are, research step 4. So I'm just going to paste this in here. I always put quotation marks to remind myself, do not plagiarize this stuff. That could be bad. So in my memo, by the way, right after I would state the statute, then I would go into, okay, here's what courts have said about it. They've said things like you got to balance it, this quote here. So that's where this would go in the actual memo. Now here's that bit from the opinion, or from the secondary source here. We're looking at NIMR on copyright, and it was making a point about the protection may be stronger where their material is fiction. And that comes from this right here. So what this is telling us is that when you're looking at this one factor, that you want to look at, let me just grab this here. When you look at this one factor, nature, it's really quite important, and the court is starting with that. So what that is telling me is that in our plan here, you want to start with this one. So I'll just make a note, start here. And that's from Oracle. Okay, and then I'm going to put this rule here. Now, because we have, we have lots of factors, to keep ourselves organized, I'll go factor 2, and then I'll put this quotation under factor 2. That will help us with that. So honestly, as I go through this, so much of it is particular to computers and software and code. It's really hard to apply it to our case. But I do notice in here that they're referencing this case Campbell quite a bit. See this Campbell case right here? They've mentioned that many, many times. So I'm starting to think that is going to be a really important case. Okay, so I'm done here. So I'm going to go back to secondary authority, go back to NMR on copyright, and see what else they have here. I'm kind of done with this Google versus Oracle. I read it. It took me about 15, 20 minutes to like read it and realize factually it's pretty different. But there is a new rule from it that pertains to us, which is that we look at the nature factor first, and it can carry quite a bit of weight. So I'm right back here where we started. So now I'm going to go through here and see if there's any case law that will help us with satire or parody. I really don't know. Is burlesque? I'm not sure if that's like talking about like the dancing style of burlesque. I don't know. So maybe this will answer that for us. Okay, so this isn't looking good here. So in Air Pirates, which we need to look at this more closely. Again, we're in NMR. We're in our secondary authority, so we haven't jumped into the actual case yet. But anyway, it says that the Ninth Circuit explained Gaslight, this other case, as setting a threshold that eliminates from the fair use defense copying that is virtually complete or almost verbatim. Well, the Hey Jude lyrics are brand new, no copying. The Hey Jude music, 100% copied. And it's copied verbatim. So I'm going to jump into this case and see if that is really what it's saying. So I'll click on the footnote here to 350, and that will take us here. I love this NMR. It always points out whenever their treatise is cited because it is like the treatise. So let me read. Now we're looking at this Walt Disney case. It's from the Ninth Circuit Court of Appeals. It's from 1978. So that's pretty old in terms of copyright law. A lot has happened, I'm learning from this treatise. And the Ninth Circuit is not binding on our court. So anyway, it's that quote really caught me though. Okay, so they're applying the fair use defense here, so I'm intrigued. I want to keep reading. Okay, so this case says that setting a threshold that eliminates from the fair use defense copying that is virtually complete or almost verbatim. So I'm going to copy that and paste that into the plan. So this rule actually goes to the third factor, substantiality of copying, like how much are you taking? And it's like, if you're taking all of the music, you've got a problem. So this is not looking good for our client right now. But this case is from 1978, and we haven't really read about this Campbell case or any more recent cases. So we're going to go and keep reading in our secondary authority. Okay, so in reading here, we come across this Pretty Woman case. This is the Campbell case. And so instead of reading their take on it here in the treatise, which gives a lot of like procedural background and history, I'm going to go right to the actual opinion here. So I'm just going to click on the footnote, and it should take us right to a link that we can get into the case. Here it is right here. So I'll open that in a new tab. Okay, so this is about the rap group Two Live Crew in the 90s. They did a kind of a satirical version of Roy Orbison's Pretty Woman. And they used it without permission, and then the people that own the copyright to Pretty Woman sued. So that's kind of the take of what's going on here. So let's see what the court said about the fair use defense. Okay, so here's like a definition of parody, and parody may claim fair use defense. So we from the Oracle case, it says you can't just copy the thing, but if you're doing a parody, it looks like that could possibly get you within the fair use defense. So I will take this rule here, this definition of parody, and put it in my plan. Now, because at this point, I don't think it falls under any one factor, I'm just going to put it here generally at the beginning of my rules here. Okay, I just found another rule in here, and this is the Campbell opinion, where it says that to be a parody, it has to comment on the author's work. So that's a problem because our song does not comment on a former work. So I'm going to put that here, sadly. Okay, I found the Contra. The commentary has no critical bearing on the substance or style of the original. They use it to avoid the drudgery and working up something fresh. The claim to fairness and borrowing diminishes accordingly. Okay, so that's not good at all. So we would obviously need to include that quote as well, because you could say our client didn't want to come up with a new tune, so she did this here. Okay, and then here we have the court's application of that rule, where we think it fair to say that Two Live Crew's song reasonably could be perceived as commenting on the original or criticizing it to some degree. So it would be a parody. And then here it is here, juxtaposes the romantic musings of a man whose fantasy comes true with degrading taunts, a body demand for sex, and a sigh of relief from paternal responsibility. The later words can be taken as a comment. Oh my gosh, it's so funny to hear their characterization of this rap. Okay, so I'm going to write up this case, do a little summary of it for my plan, and then I'll show you that. And by the way, I just reread this more carefully, and it says that this parody question comes up under the first factor of purpose and character of the use. So I'll put my rules about parody under the first factor. Okay, so I moved the main rules down here to factor 1, and then I wrote this paragraph here. You can pause and read it if you want. But this part of the court's reasoning was just so good. I'm not going to quote this whole thing in a brief or a memo I'm writing. I would just take pieces of it, but I can figure that out later when I'm writing the document. Okay, so this video, we're looking at 13 minutes here, so I'm going to create another one, and I'll keep going in our secondary authority looking for other cases. But so far, this is all looking pretty damning for our client's case.